Good evening and welcome to New Money. I'm your host, Bryan Hirsch, and in tonight's program we are focused on estate planning, offering insights and guidance to help you make informed decisions. This evening I would like to concentrate on 4 particular subjects. These are: what happens when your loved one who you have power of attorney is no longer capable of understanding what they're doing? 2, moving assets out of a trust offshore because the costs of running the trusts are far too high and the asset value is too low. 3, the implications for South Africans who financially immigrate regarding A, their tax status and their future estate and tax implications to South African revenue. And 4, how should parents be planning the distribution of their estate to children who now live abroad? Joining me this evening are Harry Joffe, Head of Legal Services at Discovery Life, and yes, he's really alive, Gordon Stewart, Managing Director of Acura. Gordon,
you see, I am human, Bryan.
You do
Barely.
Harry.
I'm not AI.
Yeah, guys, lovely to both you have on the show.
Yeah,
I can see you wearing your Liverpool shirts. Well done to Liverpool, guys.
Bryan, one day when United win the league, we'll wear United shirts.
Be careful.
I don't think we'll be around that long, sadly.
Okay. So, Harry, you just come from a board meeting. I'm sure your board were very thrilled to see the shirt you're wearing. And
they appreciate that quality,
went well. But, Harry, I'm putting the first question to you. And this is the one, we talk about the simplicity. Power of attorney is not enduring. It comes to an end. I know there's applications being made to various bodies to get that to be more enduring. But let's talk practically, because, you know, the person is no longer has given a power of attorney to you. They are no longer capable of understanding and compos mentis. I mean, we understand curatorship, I understand administration, but it doesn't really work that way. I mean, what happens in life?
So, Bryan, let's just go back a step and understand. Power of attorney is still, unfortunately, common law. There's still, as yet, not an act of parliament. The Law Society has been asking Parliament for over 20 years. There's even a proposal to legislate this like they've done in the UK, because as you said, in the UK, they allow for an enduring power of attorney. Obviously under very strict conditions, because there are security issues in that, but they do allow it. Here, because it's common law, as soon as the individual who gave their consent loses their capacity, then that consent is no longer valid and that power of attorney ends. So as you say, you've got 3 options.
Before we go there, let's understand. So now it ends. But there's so many people who still operate that power of attorney.
That is coming down a lot. The banks are now checking up. I know what we do. Every year, if there's a power of attorney, we phone the client. And we actually have a discussion with them to check if they still compass and they understand what's going on. That space is narrowing dramatically, Bryan, because there have been a couple of court cases and it's risky now.
Okay.
So there are 3 options. I'm going to talk to the main one because Gordon will like that. So obviously the best and simplest option is to use a trust. So, you know, if Dad is now lucid for a period, get him to transfer all his assets into the trust, and then, of course, the trustees run the show, and it's much simpler and much cheaper than a curatorship and much easier. There's even a SARS binding private ruling to say if Dad has now got mental incapacity and you transfer his assets to a trust and he's the beneficiary, there's no donations tax or anything like that. So there is a tax benefit to doing it that way. And that's, of course, the most effective way of doing it.
Let me stop you there. I'm going to ask Gordon to come in. Gordon, we've always spoken about the cost of trusts. And whereas South Africans for many years just asked family, friends and to become trustees, no one ever charged for that. I mean, I've had a few situations where I am a trustee and there are other trustees, and I've suggested to the settler and founder, you know, you need to start paying these trustees money. And they're a little bit surprised. Well, what does the trustee do? They come to a meeting, not understanding the obligations. So Harry's idea, just want you to understand, the guy's only got 10 million, he's got a home, he's got 5 million rands worth of assets, enough to sustain him, doesn't pay to form a trust.
Yeah, Bryan, and I think that's where it starts getting quite tricky, because as you say, it's got to be cost efficient to the extent that there's no point in, you know, you've talked about figures of 5 or 10 million rand.
Yeah.
You could probably still, you know, if you've got a professional trustee who charges, I don't know, maybe 50,000 Rand a year or something to fulfill that capacity, at least there's still justification behind the trust. But when you're starting to talk about the really low amounts, maybe a couple of million Rand, then it is a big problem with regards to what's the point in setting a trust up for that amount of money, and a lot of it, well, a lot of the return on investment disappears off in fees.
Because then you've got the cost of a trust. So Harry,
Bryan, let me come back to that.
So then the cost of the trust.
I mean, I agree, and I agree with what Gordon's saying. But remember, a curatorship is going to be more expensive.
No, I understand that.
Curatorship's an application to court,
so
ongoing.
Yeah,
so
I can understand
right?
the bigger estates. I'm understanding this general estate, someone who's got enough money to sustain themselves.
Yeah, I would say for 5 to 10 million, okay. But for a much smaller estate, there's of course a third option, and that's a master's administration letter. So in terms of the Mental Health Act, you can ask the master for a letter where they give that family member power to administer the estate for the incapacitated person. Now the problem is, in terms of the Act, it's a very low amount. When I last checked, it was about 200, 300,000 rand.
No, I thought it was some ridiculous amount.
But in practice, the master does give that letter for bigger estates. Now, I mean, that's not satisfactory because the law obviously is in a state of uncertainty there. I know up to R1 million, the master will give that letter. So that's the solution for a smaller estate. Between 1 and 5 million, well, there's no...
You're in a grey zone.
Exactly. There's no perfect solution. I would say the trust is better than a curator because a trust at least is manageable in terms of the costs. Curatorship is a lot more expensive than a trust. So,
and I think, yeah, and true. I mean, from a South African perspective, you can still get away with having, you know, maybe 2 family members plus then the independent trustee.
Correct.
So a lot of the admin work could be done by the family members, and then, you know, keeping the costs down. But when you've got overseas assets and you're looking at an overseas offshore trust, that cannot be managed by the family members, and that's when the costs do start becoming kind of material based on the size of the assets in the trust itself.
And Bryan, I mean, as Gordon's saying, negotiate. Say to the professional, we want you to do the tax return, we want you to do the, you know, the anti-money laundering reporting. We'll do the basic admin. We'll do the notes of the meetings. We'll send out once a year the resolution to sign. We'll do the basic, you know, donkey work. You do the half.
Okay, but let's just talk about the more simplistic things. The paying of accounts, the getting money out of the bank account, paying staff.
That the family can do. I mean, that you don't need. You just get the resolutions passed and the family can do that.
When
Hang on, you said paying staff there, Bryan. Is there running a company here? Because
no,
then that takes on a whole...
individuals.
Oh, you're talking about domestics.
Yeah, I mean, that the family can do.
The family
you want the
could do
professional to do the legally difficult stuff.
Okay, let's come back. When you say you want the family to do it, under which regime are you talking about?
No, so you'll get a resolution passed, right? The resolution will pass allowing the trust to pay the domestic
No, we don't have a
worker.
trust. I have assets in my name.
No, so you get the assets into the trust, Bryan. You have 2 family members and the professional. You pass a resolution at the beginning of the tax year saying they can pay the following staff members, and then the family do that. The professional's job is to do the tax return, to check the resolutions are being done, and to do the anti-money laundering.
But I think where you're going with this, Bryan, is that grey zone, let's say between 1 million rand, which Harry was talking about, the master's administrative letter, and then, you know, 10 million or so upwards, yeah, you could bring in the trust and then carry on with what Harry's talking about. It's that period, or that amount in
1 to
between.
3 million kind of thing.
Yeah, that's tricky. I don't think there's a clear answer on it, because you can go, as you say, you've got the curatorship, but the curatorship's also, you're just giving it to someone else to do the admin work, and they're going to charge
ongoing
you for
fees,
it.
because the curator, every time they do something,
they're going to
charge
you.
It's an advocate, so that's worse.
It's tricky. I don't think there's a clear answer.
No, there's no simple solution. We've got to make a humble bequest to Parliament to change the law. That is the only
You say this has been going on for 20 years.
over
not
20
longer,
years.
eh? Longer.
But surely,
1999 was the first law.
But you know, if you think about 20 years, 25 years' time, I mean, when you talk about dementia and you talk about those type of ailments that now people at 75, 80 are starting to endure, I mean, it just seems... So let's just talk about, okay, if you want a curatorship, that takes time.
Well,
And
and
it's
there's a
costly.
problem, Bryan. It's costly, and of course, you have to bring that incapacitated person to court.
Yeah.
And there's been a case, and it was a case in the last 2 years, where that incapacitated person came to court and said, there's nothing wrong with me, this is nonsense. And the judge dismissed the application for curatorship.
Because remember, you're changing the person's legal status.
Yep.
So they can no longer now go and enter into contracts, open accounts, etc. So to change the
Emotionally, it's a
person,
difficult thing.
it's like basically taking a major and making them a minor again.
Okay, so I want to get on to the other questions, but so let me ask you a question. We've got viewers this evening who are very interested in the subject. We haven't really given them any tangible solution.
Well, there's no perfect solution.
There is
Bryan.
no
There's no
solution.
solution.
That's the problem.
I'll tell you the solution, Bryan. They must write to their member of parliament. They must write to the minister. and I say change the law.
Okay.
That is the only solution.
It's been going on for donkeys.
which they're not going to do. So,
Well, enough pressure they would. If, as you say, it's becoming more of an issue now. 25 years ago wasn't such a big issue. Now we've all got clients in that
so you
position.
guys,
Big issue.
Gordon, you have a mother. Please, I don't know if your mom's still alive.
No.
Okay, but you have a family
Yeah.
member who you can see, a sister
Yeah.
who's getting in this way.
Oh, I can give you a practical experience.
would
My
you do?
dad had dementia.
Yes, what did you do?
Luckily enough, he'd done his planning in advance, so he had a trust. So it was, but exactly what we're talking about here is an individual. He was a very smart man. I don't know where I came from. And he...
Sorry, what did you say?
I don't know where he was a smart man, and I don't know where I came. I must
Gordon, the
have been
people who
adopted.
watch your program, believe me, think you're a smart man.
And he got to the
He had all
point...
his hair, didn't he?
Yeah, no, that's also true. But he got to the point where he was just unable to look after his affairs anymore. But luckily, Bryan, he already had a family inter vivos trust in place, and that then continued to look after.
Once it's in a family trust, the emotional stuff goes away. Because
Yeah.
the curatorship, you're actually making an application to court, and this individual now has to be told. In a trust, everything just carries on as normal.
Just before we take Adrian, one last question. The person's already given someone power of attorney, and they already are not able of conducting their affairs.
No, but then that power of attorney, in theory, shouldn't be. It's not
It's
valid.
And Bryan, even those people we found do have lucid moments.
Yes.
So in their lucid moment, they can transfer assets to a trust. As long as you can get it confirmed they're lucid.
Yeah.
Okay, let's take a break. We'll be back shortly.